Parliament is currently considering a law that would allow the state to put someone in prison for up to a year if they do not ensure that their children are going to school regularly. It's part of the Basic Education Law Amendment Bill. It's a wide-ranging bill. It looks at changing the way language and admissions policies work. It would also allow alcohol to be sold on the school premises during certain functions. Let's get two takes on this. Cecile van Schalkwyk is an attorney at the Legal Resources Centre's education program. Jane Borman is a researcher at Equal Education. Good afternoon to you both, and thank you for your time. Cecile, let me start with you. You're worried about the provision that would send people to jail for 12 months if they don't make sure their child is at school. I think that's relatively similar to the law now. It's just a stiffer sentence. Why are you worried about this?
Thank you, Stephen, and thank you for having us. I think anyone who works within civil society and works with people whose children struggle to go to school for whatever reasons know that very often children who don't go to school don't do so not because their parents don't want them to or their parents are obstructing them from going, but because there are real challenges in these children accessing schools. Very often it has to do with scholar transport. Children may have been excluded from schools because they don't have the required documentation, which is also something that the bill addresses. And you know, from a very practical perspective, punishing parents or guardians or caregivers by putting them in jail, you know, the way we sort of view that is that it will have exactly the opposite effect of getting a child into school if the person who's primarily responsible for their care is not there to actually ensure that they do so. So our approach is that instead of putting them in jail, there should be a much more comprehensive approach to that family situation, making sure that those families are supported and that those children are given the required support to be able to actually access school and whatever form that takes, whether it's scholar transport, whether it's support in other means of accessing schools.
Jane, I mean, don't we need to send a message as a society that it's very important that children go to school and sometimes you need to use a little bit of a stick to do it?
Yes, well, thank you again also for having me on. I think the problem is that, you know, there are many ways to create a strong message that parents need to send their children to school. And, you know, there are multiple ways, you know, parents' education, you know, trying to address issues in communities that would allow their children to attend school. Criminalizing parents is simply completely out of whack with the actual problem that we are finding here. Like Cecile said, you know, the issue isn't most of the time that parents are simply saying, I don't want my child to attend school. So criminalizing a parent, you know, is sending a message in some way, you know, that, oh, this is very, very important, but it in no way actually attempts to address the issue. So, I mean, for us, it's a overzealous and heavy-handed way of trying to send a message to parents without actually dealing with the real reasons that children aren't in school.
Cecile, there's a big issue around documents. You've already brought it up, and I presume these are documents that parents have to submit. I would imagine a birth certificate, maybe documents proving a learner, a child is South African, able to go to a school. What are you worried about here?
So, Stephen, the new sort of proposed amendments to the Bala Bill introduces quite an extensive list of documentations for that needs to be submitted to school. And in addition to the birth certificate, if the child is South African, for example, it also requires the documentation of the parents and makes specific provision for parents who are, for example, asylum seekers or people who've been granted refugee status. And it, you know, so it just requires that these documents must be submitted to a school for a child to, you know, presumably gain access to the school. Now, one of the issues that we've got with that is that it is completely contrary to a 2019 judgment of the Makanda High Court, which said that children who are undocumented must be allowed access to school, you know, whether they are South African children, whether they are non-national children. Everyone has a right to access school. And the court specifically said that where a person or a child is undocumented, in those instances, they must submit an affidavit or a sworn statement to the school identifying themselves, and that is sufficient to gain access to school. The thing that we are really worried here is that the Bala, first of all, contravenes that judgment, but also it introduces you know, requirements now for parents, for example, to have to submit their documentation, you know, which rings alarm bells, because the question is, why do schools need parents' documentation, you know? And is it not a way, perhaps, of introducing some immigration control mechanisms? So that's sort of, you know, part of our concerns around the documentation issue. And one of the other concerns is that it doesn't really create a category for people who are completely undocumented, which we know is a very large group of children in South Africa. During the course of that litigation, the Department of Basic Education at that stage indicated that there were about 1 million children in the South African school system who were undocumented, of which about 83% of them were South African children. So we know that if there's no category for these children, what happens to those children that are undocumented, that aren't addressed in the new BALA legislation?
Jane, I mean, if you want to stop someone from doing something, make them do a lot of paperwork. I mean, surely we're not going to stop children from going to school because of paperwork. And I'm sure I remember speaking to Panyaza Lesufi, a Gauteng education MEC years ago, in which he said he would never allow a child to be prevented from going to school simply because of paperwork.
Yes, well, I mean, you know, the BALA bill does state that, you know, while waiting for all the documentation to go through, the child is allowed to start attending school. But essentially, you know, to touch on what Cecile said, there's a real concern that all these additional steps are not once again in the child's best interest and are actually about ensuring the child has access to school, but is actually, you know, one of the new additions is this creation of this intergovernmental body that will be able, that you can refer a child that doesn't have documentation to this body, and they will, you know, obtain the documents necessary for the child to go to school. But like was said, with this introduction of, you know, documents regarding parents and parents' work status, etc., you have a problem where on this intergovernmental committee sits SAPS and sits the Department of Labor. And so really there's a strong possibility that this intergovernmental committee could, like Cecile said, act as immigration control, and could even, if undocumented parents are aware of it, prevent them or scare them away from wanting to go through this process, and so they won't bring their child to school. So, you know, I mean, obviously, we are very, 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 very concerned about this from multiple angles, and we feel that it's completely unnecessary.
Jane, the other issue is alcohol, and the idea, as I understand it, is to allow a way for schools to be able to sell alcohol on the premises, obviously not to learners, but at school events, sports days, things like that. I imagine they'll use the money for fundraising. A lot of people are very opposed to that. Are you?
Yes. Well, you know, to state the obvious, I mean, alcohol abuse is something that is very prevalent in South Africa in multiple communities, in most communities actually. And for us, we are deeply concerned that introducing the sale of alcohol on school property or during school activities, you know, obviously there are restrictions, will really open up children to potential harm, whether that harm is coming from being around inebriated adults, whether that harm is coming from having easier access to alcohol and therefore perhaps underage drinking, which is obviously another issue that we have seen quite clearly. So, you know, we and many, many communities and parents around the country are really strongly saying that we do not want the sale of alcohol at schools. Schools should be safe spaces, and we are concerned that this will jeopardize it.
Cecile, there are a lot of issues in this bill, and we're not even going to be able to go through most of them. But one of the things that, as I understand it, is being proposed is that the education department or a head of department in a province would have more authority in determining the language policy of the school rather than the school governing body, as is the case at the moment. There's a whole process that's spelled out, but in the end, the head of department would have the power. And we should probably talk about what we're really talking about, is the thing that we see every year where a school that generally teaches in Afrikaans is accused of using that language, of using language policy as a proxy for race. Where do you stand on this? Is it right for the department to take more power from the school governing bodies at a time when we want school governing bodies to play quite a big role?
Yes, I mean, you know, the LRC's position has been that we sort of welcome this amendment and making sure that, you know, as you say, that language isn't used as a basis for discriminating against certain learners, or as you say, a proxy for race. That definitely does happen in certain areas of the country, and it specifically happens, I suppose, in the former sort of Model C schools. And as you pointed out, I mean, the way in which the bill is framed is to sort of put a process in place for the adoption of a language policy. The governing body retains powers of appeal. They are able to challenge the HOD, and of course, if they are unhappy with the decision of an HOD, then the option of approaching a court to set aside the decision of the HOD still remains open to them. But I think what the bill really tries to do is to say, schools are spaces in which we want to teach all our children, irrespective of the language that they speak. And we want to stop this system whereby language becomes a proxy for race and a proxy for exclusion, making sure that schools can sort of, look a certain way and remain to look a certain way. So we sort of, we support that kind of idea that the HOD ultimately has the power to decide, subject, to the governing body retaining some kind of procedural powers to be able to appeal that decision and then take it further if they want to.
Cecile van Schalkwyk, an attorney at the Legal Resources Centre Education Programme, Jane Borman from a researcher at Equal Education. Thank you both, I really do appreciate it. It's an important piece of legislation that's going through Parliament at the moment, the Basic Education Law Amendment Bill. I'm sure you'll see more conversations about it in our society.